Hello and good evening, everyone. Welcome to Wednesday Night Live from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you all so much for being here. I see a lot of familiar names. Hello, Jody. Hello, Shell. Hello, Miss B. Hello, who else do we got here? Hello, Andrew. Thank you, everybody, for carving out some of your Wednesday evening or I don't know, morning, depending on where you are in the world. And hello to those people who are going to be tuning in for the replay of this as well. Thank you so much. We have a lot of new names as well. So I want to introduce myself. My name is Joshua Ritter. I was a former prosecutor with the LA County District Attorney's Office for 10 years. I am currently a criminal defense attorney. This is Courtroom Confidential, and we try our very best. The mission of this channel is to try to give you a perspective from both sides of the courtroom and be as objective as we possibly can. Thank you for joining us tonight. Tonight is a special night to join us because we're going to be talking about the Bryan Kohberger case. There's been a bunch of new rulings that are going to have a huge impact on this case. I've said this before, but the real lawyering, where the rubber really hits the road as far as being a good trial lawyer, is what you do in the pretrial motions, in the in limine motions, in those evidentiary hearings, deciding what is going to be the landscape of the law. Because any lawyer can get up and talk and be dramatic and bring theatrics, but if you don't have anything to talk about, you're not going to get much done. So this is where it really is important. And to talk with us about all of those rulings, we are bringing back Kevin Fixler from the Idaho Statesman. We did a case notes episode on the Bryan Kohberger case, the Idaho 4 case, with Kevin when we sat down to interview him. And it has quickly become the most popular episode that we've ever done on this channel. So we're very grateful for all of you for watching it. And we're very grateful for Kevin for being a part of that. And so we decided to bug him and take advantage of his goodwill and bring him back again tonight to talk about Bryan Kohberger again. But to run our poll that we always do on a Wednesday, the cases that we can talk about with the time that we have remaining are Menendez brothers. They are back in court again this week. I've been following that case closely because I've been doing some coverage for our local ABC affiliate on that case, and it's got some interesting stuff to talk about. Also, there's a development in the Shanna Gardner case with Henry Tenon. Interesting development because he is the star witness for the prosecution in that case. This was the murder of her husband, Jared Bridegan, the Microsoft executive. And then finally, Karen Reed. A new movement by the Commonwealth on that case. I'm not going to talk about every little issue that's come up recently on Karen Reed, but one issue in particular that I find to be fascinating, and that's about Karen Reed and her interactions with the media. So Menendez brothers, Henry Tenon / Shanna Gardner, and Karen Reed, those are the poll that we'll put up now. But before we get to any of that, and before I continue to carry on too long, I want to introduce our very special guest. Please welcome Kevin Fixler. Hello, my friend. How are you?
Doing well. How are you today?
I'm doing very, very good. Thank you again for doing this. And I was telling you before we got started, we are so pleased with the final product of that case notes interview that we did with you. And that was all possible because of your help. So thank you again. I hope that you got a chance to watch it yourself because it really turned out well. And the feedback that we've received from people has been fantastic because I think we accomplished, I hope to a certain extent, what we set out to accomplish, which was give just kind of an objective, facts-based approach to what has happened in that case. So thank you again.
Yeah, well, thanks to your team for making me look good.
Oh, absolutely. But some things now, of course, as would always be the case, since we recorded that, there's been a whole bunch of new filings and a whole bunch of new decisions. And so I wanted to dig into those with you tonight. And you've been sitting in court for all of these, so you're the best person, I feel, to talk about this. There have been, and this is information I can trust because I got it from your recent article that you wrote on the Kohberger case, and that was over 170 legal filings in this case, dealing with what the evidence is going to be in this case, and many of them are coming to a head now. Is that right?
Yeah, so last Wednesday we had the hearing, long awaited, for the motions in limine, and between the two sides, both kind of jockeying for position on what they want and how to kind of tailor the way certain evidence will be described to the jury and what may make it or what may not. There were about 170 filings, including some sealing orders from the judge, and that totaled over 1,000 pages of filings, which you as an attorney can appreciate. And this isn't what I do for a living necessarily. So looking through all those with my colleagues, it's taken a lot of time. But we did finally get there. And on Wednesday, Judge Hippler held this hearing. It was actually supposed to extend into 2 days, but they did a marathon 7-hour hearing. We got through all of them, including 2 new attempts to strike the death penalty. And we'll see where those two stand. The judge did not rule on those particular issues, but he did issue a handful of bench orders on some, and then in several instances, he basically said, the rules of court dictate that you couldn't do some of those things anyway. So they kind of are a status quo. I don't need to issue an order over potential prosecutorial conduct, and so we still have several outstanding, and we're awaiting those. One dropped today, kind of a minor one that I'm sure we'll get to, but beyond that, we're still waiting on most of them.
You put in your article a quote from the judge that I really love that I want to read, that talks about how I think it gives a good insight into how this judge thinks about this case and all of these motions. But I will say, listen, in any death penalty case, you're going to have more filings. People are just going to do more because they want to preserve all of those issues for an appeal, which will be coming if there's a conviction, I should say. And 2, because of the consequences being so high, you're just going to see a far more litigious defense team. And these people have proven that in spades. And a lot of these things I do feel like are probably motions that in a normal case. And what I mean by that is like a murder case that wasn't a death penalty case. You would probably see a lot of this stuff just brought up orally, but they put it down in paper and they write it out and actually want it motioned up and heard by the judge. But the judge, in response to kind of this discussion on, and we'll talk about this as our first topic, there was an objection by the defense on the use of different words. They even want kind of the vocabulary of the trial laid out. And they don't want him referenced as a psychopath, as a sociopath, or even as a murderer by anyone. And the judge said that a lot of that is about argument anyways. That, if the prosecutors were start to refer to him as a psychopath or a sociopath, that's obviously just labeling an argument. But even calling him a murderer, if it's not during their argument portions of the trial, he doesn't want to see that. And he said, I will tell you one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this. I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it. So he is not pulling punches. He's really laying down the law as far as, I don't want to see a bunch of nonsense. What is his demeanor towards these attorneys? Is he kind of, bringing the sheriff attitude to them?
I don't know that we've quite seen that so far. I think, for those following the case, we saw Judge up north before the case was moved. And I think certainly at least one of the families was outspoken about how there was a bit of nonsense maybe, and even a little bit of joking around, making light of circumstances which upset them, offended them in some circumstances. I think Judge Hippler down here in Ada County, which is where Boise is located, for those not in Idaho or not familiar, he's known as a bit of no nonsense. He runs his court a bit more like a federal court, and he's the administrative judge for the county. So he is in many regards setting the tempo, setting the guidelines for other judges to follow for the county. And of course, the attorneys on both sides are needing to know his approach and his tact. And I wouldn't say that he has admonished per se. He certainly told them with regards to revealing discovery for expert witnesses to over disclose, and so gave both sides a larger opportunity to reveal more so that we have more information than less and ensure that there's no issues during the trial. And hey, where is that in your filings? Their testimony was not stated that way. But I think as you're seeing, and as you pointed to with that quote, he also had another about, hey, I told you from the get-go, we will not accept theatrics here. This really is about, following the Idaho criminal rules, the law, and the expectations of decorum within the court.
And as well, it should be. This is an incredibly serious case. I mean, you've got the four sets of families, who are going to have loss in their life they will never recover from. So just about as serious a thing as you can handle from that perspective. And then you've got a gentleman on trial for his life that the state intends to put him to death. So every way you look at it, this is a case where, there should be zero tolerance for nonsense. And I appreciate any judge who says, listen, I'm not going to remind you of the rules. You know the rules, follow the rules, and we won't have to argue to make sure everybody follows the rules ahead of time. Now give me the actual things we need to discuss. So I kind of wanted to bring that one up first because I loved how he set the table. But one of the more, getting to more of the substantive things, there's a video of a traffic stop made before the murders took place. This is a still from that the prosecution wants to introduce, and they want to introduce it for the purpose of showing ownership of that vehicle. You can even see the symbol there. That is they believe to be the Hyundai Elantra that's at question that was seen, captured on video around the time of the murders. And the defense is saying, however, that this can become more prejudicial than probative. And there's some interesting, at first I thought, what a nonsense argument to make. Nobody's going to convict this man of murder because he got a traffic violation. But they're saying, and this kind of bleeds over into even the autism discussion we're going to have a little bit later, that they're saying there's a behavioral, a way that he conducts himself and the way that he discusses things that they feel might be prejudicial to him, because during this stop, he talks about asking, why do I need to show you my ID? And discusses something about having to wear a seat belt. Did the judge come to a ruling on this, or how did that all end up playing out?
So let me just first clarify that the still image that we see here is actually from a stop by the Washington State University police for.
Oh, that's not the one that's in contention.
Right. What became so interesting. Yeah. So just quickly, this was over a red light, running a red light allegation from a WSU campus officer. And we have seen this video. We've seen the stills. We've seen the dialogue with him and the officer. The difference is the video that was in question had never been released. It is the one traffic stop. It was the Latah County Sheriff's Office in August of 2022. The state alleges that this was one of the trips that Kohberger had made to the vicinity of the home, which was a concern for the defense. And what it is through public records, we've never actually had access to that video. And so in court on Wednesday, what we learned was some of the back and forth he had with the deputy, and it was for an alleged seatbelt violation. And Kohberger had questioned, why do you need my ID? Why do you need my phone number? The state wants to use this video, they say, for the purpose of establishing one of the things you mentioned, which was which vehicle he owned. We can say this is the car that he drives and owns. We know his phone number and we know his positive ID. The defense has said, yes, but the dialogue in that video might prejudice Kohberger, because the jurors will see that he has an adversarial relationship with police, perhaps. He may have been trying to hide something, might be the perception. And so they were trying to limit or completely remove the ability of the state to show this video to jurors. Hippler ruled that the video was relevant. It can be shown, but he did say he wanted to review the transcript and watch the tape for himself, which the defense provided, to decide whether or not there is prejudice to Kohberger. And essentially they would redact those portions other than those that the state wants it to use it for, to establish those pieces that it's him, that it's his car, and that it's his phone number, which they then use to get search warrants later tied to that phone number.
That is interesting. And that even brings an entirely new perspective to the way I'm thinking about this too, because now I'm wondering, if you're the prosecution, why don't you jump in both feet and say, yeah, we want to show that he doesn't want to turn over his ID, because it is part of our theory that he did not want to be identified in a traffic stop while he was in, because this is, you're saying like now near the location of where the murders took place, right?
Yes, it was, well, I can't say whether or not he was there or not, but yes, I got you.
In other words, if they're trying to say that this could have been him scouting that location, then there might be an argument to be made that he doesn't want to leave a trail with law enforcement when he's out scouting the location. And I wonder if the prosecutors, I'm guessing they didn't make that argument, but I wonder if they should have.
They did not, and they said, they referenced what you did earlier, that it's ridiculous, and the judge agreed that a juror would see what could be perceived as prejudicial information in this video and draw the conclusion that he has a history of moving violations and thus committed these murders. But
interesting.
The defense pointed out that this happened on one of the days in which Kohberger is alleged to have been in the vicinity of the home, and that the state may try to bring that up at trial, and thus they wanted to limit the way in which it could be presented.
Interesting stuff. Even these little things that you think, where are we going with this? They have a very interesting, nuanced touch to some of them. We talked a little bit about the family attending. And tell us again, what did he finally decided he wants to hear from the prosecutors as to what exactly they intend to ask them, so that he can figure out what, in other words, just to set the table for everybody watching. In most trials, there's a motion to exclude any witness who has not testified yet from attending the trial. So the issue here is, if his family members are on the witness list, then they might not be able to attend the trial until they're called as witnesses, and we don't know when that might be. And the prosecution doesn't want to call their witnesses out of order, because they have a story they want to tell, and sometimes the order of witnesses is important. The judge realizes, though, that it's also important that the defense have his family there for a very important trial and for family support. So tell us again, how did the judge come out on this?
So the ruling actually came down today. It's the first of any of the written orders that Judge Hippler is expected to issue from last week's hearing. This one was, I don't want to call it a layup, but he did confirm that all of the victims' immediate families can attend, which is allowed in Idaho. I can't say in other states. It's not my expert area. The defense also asked for a ruling over the decorum in the courtroom. The Gonsalves family, as an example, had previously worn T-shirts and sweatshirts that promoted a new law in Idaho that permitted a firing squad execution. And I saw them do this in the past. I can't say for certain whether or not they did so actually physically in the courtroom up north, but this, without question, Hippler said no such thing will be allowed in our courtroom. That was in the ruling today. He confirmed that the rules that govern the courtroom would not allow such a thing. And then the new piece was basically him putting pen to paper to confirm something he said last week, which was that there is a balance here. We do need to acknowledge that Bryan Kohberger deserves to have his family support. The defense went to bat for him and said that's very important. He speaks with his family consistently through the phone system in the jail, and they support him. They want to be there as soon as they can, but the state may call, and it does seem confirmed, they will call some members of Kohberger's immediate family. He has two older sisters. He has a mother and a father. We don't know who they may call. They said they're only going to call some, but didn't identify who those people will be. But the question was, well, when will you call them, in what order? And does that preclude his family from attending? Hippler said, I want an in-camera ex parte meeting with the state to understand what that timeline is and what it is specifically you want his family to testify to. It probably is limited in scope. And so let me understand better what that is. You need to file that by April 25th, what that is, and then I will review it. We will have a conversation, and then I will issue a future final order on this particular issue.
Interesting. So, and again, just so everybody's up to date on this vocabulary we're using, an in-camera ex parte hearing means that it done privately in chambers and with only one party present, meaning just the prosecution. So it's an opportunity for the prosecution to say, here's what we're calling these people for and what we expect them to testify to, so that the judge can make an informed decision regarding these issues about when they'll be called. So that's interesting. I will say that I feel like most judges, I feel like he is giving some deference to the family here, which I applaud, but I feel like most judges would say, listen, they're witnesses. It's the prosecution's case. They can call them when they like. And it doesn't sound like the prosecution's being like vindictive to try to keep them out, but it's nice to see that the judge is being thoughtful about all of this. All right, let's move on, because these are now the big issues. The first one being the Amazon search history. So again, to set the table, there is evidence that we are being told by the prosecution now that they have evidence to link him to a shared Amazon account that shows purchases for a K-bar knife, sheath, and sharpener back in March of 2022. These murders took place on November 13th of 2022. And very significantly as well, that he also searched for that same knife and sheath sometime after the murders took place. How was this handled, and where do we fall on this right now?
This was one of the few bench orders that Hitler issued. And his point to the defense was, how is purchasing something on Amazon prejudicial? And we know why this is important, because the knife sheath, we have a picture of it there, something similar was found at the crime scene inside the home next to the body of one of the victims. And on top of that button snap, which is on the upper left, it's not snapped there, but around the rim, they found DNA that they eventually linked to Kohberger, allegedly. The defense is not disputing that. So it becomes this greater question of, how did the knife sheath get there? What does that mean? Does that mean it was, direct contact? These are things that will be debated. But Hitler decided that the Amazon activity, they're calling it click activity, but essentially it's just data about purchases, searches, what's in your basket, etc. That is allowed at trial. There will be no limits on that, according to what he ruled in an order. I do expect he'll probably issue a written order that will confirm what he said at the hearing, but this was what he indicated. Essentially, this was I would call it a significant loss for the defense, and if not a significant win, at least maintaining what is part of the narrative and for the state, what they believe happened, that he did in fact own these things at one point, and whether or not it ties him directly to the crime scene, that's up for a jury to decide. But he did rule that those things are allowed, including the search history after the fact. One thing he did reveal that was sort of new was that Kohberger allegedly bought those items with a gift card. We don't know more about that at this point, but it was a gift card through the family account. Hitler also said, maybe a little confusingly, I'm not sure how this would work, but that it was a family account, but essentially they have a way to identify that it was actually under somehow that it was tied to him directly within the family account. That may not be exactly correct, and we haven't seen those sealed filings, but that is how he described it at the hearing on Wednesday.
Interesting. And this is me just guessing. I wonder if it has to do with kind of IP addresses, and they know who was accessing this shared account, where that computer was located at the time it was being accessed, and if they know where the family members were at certain times, maybe that's how they're doing it. I don't know. I know I have a shared family account, and you can't really tell who's, it doesn't identify who's on. We all just use the same logon information, but maybe some accounts are set up differently. And I appreciate, Kevin, so much how you have maintained your objectivity throughout all of this, and I am respectful of that and don't want to press you on these things. But in my view, I can be a little more free with my opinions on this. Aside from the DNA on the knife sheath itself, the fact that they were able to find these purchases is, to me, the second most devastating piece of evidence that we have heard about thus far in this case, because this whole case to me hinges on that DNA. I don't think it even gets filed without that DNA. But when they find the DNA and they're able to tie that to Kohberger, then they have enough to file. But then the question still became, how did it get there? And from the defense's perspective, I had always said that they're either going to have to legally challenge this or provide some sort of innocent explanation for it. Their legal challenges, they lost them all. It's coming in. So now you're left with, how do you provide an innocent explanation? And they will not now, I feel, have the opportunity to make an argument of, this man's never seen a K-bar knife in his entire life. He never even knew what a K-bar knife was until he got charged with this crime. All of those arguments are now out the door when you can say, by the way, this guy, coincidentally enough, purchased the exact knife we feel that was responsible for these murders several months before the murders take place. To me, that is a huge piece of evidence for the prosecution. But it brings up the next point, which is, okay, now we're down to what exactly type of DNA are we dealing with here? We're not dealing with some sort of bodily fluid. We're not dealing with blood or saliva or sweat or something like that. We're dealing with what is called touched or contact DNA. And this has even become a point of contention with the defense challenging one of the Idaho State Police, one of the intended witnesses, who is an Idaho State Police crime lab manager. Tell us how that played out. What are their arguments? Did the judge make any decisions on this issue?
So it's kind of a twofold issue, and I'm going to consult some notes on this because I'm no expert on this either. But there was debate between both sides, and that was over. I'll get to Riley Nolan, the expert herself, but the issue was over touch or contact DNA and the use of that language. And I think for us lay people, we hear the term touch and we assume it's something that somebody directly touched. And this apparently in the DNA forensic field is evolving. Kohberger has a newer attorney who has a background in forensic DNA. She was brought on in the last month or two, and specifically for this purpose. And you can tell because she made those specific arguments in court on Wednesday, talked about how the field has really evolved, and really the term touch is sort of alt-modish. It's not really even used in the field. What's interesting is the judge, Hippler, he actually pointed out, well, you might say that, but not only did the state's expert witness on this issue use that term, so did your witness. So did your expert on the defense use that same terminology. And so I have questions about whether or not we should allow this term or not. Well, he did say, I'm not going to be able to police the experts and how they choose. And I'm not an expert in DNA either, basically. And so if that's language that's used in court before the jury, I can't restrict that. But I am going to dissuade the attorneys from both sides from using that language as best they can. And then, as you pointed out, it's connected for the state to one specific witness who was expected to testify to that. Her background and expertise, the state says, allows her to offer an opinion that this is probably primary touch, meaning direct touch to the item in question, which is the knife sheath. And the touch, the DNA is skin cells, essentially. And so her perspective is that Kohberger touched this directly, and she was expected to testify to this. And then it's left at the crime scene after this incident. The defense is saying that's not legitimate. There's no science behind that. She doesn't have the expertise, hasn't taken coursework to justify that type of opinion. So Hippler ruled on the touch and contact issue. He held back a ruling on Riley Nolan's ability to testify or what specifically she can testify to. So that one is forthcoming. Oh, wow.
And that could be huge. I mean, going back to my point about some sort of innocent explanation for how your client's DNA is on there, that comes down to that question alone, maybe. Is it a direct touch? In other words, did he physically make contact with that knife sheath and specifically that snap? Or was that somehow transferred there? Because touch type DNA is something that there's studies and science and experts who will testify that doesn't necessarily mean that person touched that item, that their DNA could have been transferred there, by some other means. And if they have an expert, the prosecution saying, no, we believe it was not transferred. In other words, not planted, either nefariously or accidentally, meaning that he never even came into contact with that knife sheath, that might give the defense a fighting chance here on explaining how his DNA ends up there.
Right. I've heard from whether it's kind of web sleuths or some experts in the field that there is some precedent, and perhaps you even know it. There's a case where there was indirect DNA transfer, I believe we'll call it touch DNA just for our purposes here, and the person was wrongfully convicted. So there is a belief that that could be a viable argument, if not for if they go with the route of saying that it was planted or inadvertently it got there somehow. I mean, I think we saw that in the OJ case. I watched that 4-part Netflix special, and that was a big part of Gary Scheck's argument that the police mishandled this, and you were at both scenes, and it ended up here. And of course, there was spoilage of the DNA, and that was in early days. But this is what I think we can expect. They're fighting tooth and nail for every potential win and an opportunity to try to explain how this piece of evidence ended up at the crime scene, and what are the ways or the narratives in which it could have gotten there, but not actually been Bryan Kohberger who committed this crime.
Yeah. I love that you brought up Gary Scheck, because you and I have actually talked about this. He was, in my view, the lawyer in the OJ case. I mean, I think many defense attorneys look back on that and feel like, Johnny Cochran kind of gets all the glory for the, if the glove don't fit, you must acquit kind of, show business atmosphere that he brought to that. But Gary Scheck is really the one that chopped apart the prosecution's case, and in ways that the prosecution could not even see coming. I mean, he was really a master on just continuing. This is probably the wrong metaphor to use, but it was this death by 1,000 cuts against the prosecution case and creating doubt as to how this evidence ended up anywhere. And at the end of it, it was kind of a mess to even people who were watching objectively. And I think that they just to play kind of defendant's advocate in this case, if they are able to call into question this touch DNA, and I'm going to use that word again, that term, just because it's easy, how it got there, whether it could have gotten there by other means, any other means other than him touching it, that's really the only DNA we're dealing with. Because shockingly, there was no DNA linking him to the crime scene recovered from his vehicle. There was no DNA linking him to the crime scene recovered within his apartment. So the only kind of physical evidence that links him to this is that touch DNA on the snap. And I could see, this whole case is going to come down to a huge battle over that.
Yeah, I mean, we'll see. I think you've highlighted several times. It's obviously pretty significant evidence. It is the defense mentioned more than once, 2 different attorneys, that this is a highly circumstantial case. They wanted to beat that drum and make that point in the hearing the other day, but it's the wealth of circumstantial evidence. And as police built the case and explained that once they had the tip, quote unquote, from the FBI on the investigative genetic genealogy, and then they kind of reverse solved this, found the vehicle. Lo and behold, Bryan Kohberger appears to drive a car that's very similar, if not identical, to the one that they have on videotape from nearby the crime scene. And then you also have the cell phone information. Once they ran AT&T records through search warrants and got all that information, lo and behold, his cell phone was either off or on airplane mode during the exact window of the crime, again, according to the state's narrative. And, it pinged on the way in and it pinged on the way out. And they have video footage from public cameras around WSU to show some triangulation. And that's clearly going to be the state's case, built not exclusively, but certainly around the DNA evidence found at the crime scene.
Yeah, it is a circumstantial case. I mean, you don't have an eyewitness to it. You don't have a confession to it. You've got a bunch of circumstances that point towards one one individual, and it's just a matter of the prosecution putting that together in a way that the jurors can wrap their heads around. Let's move on to some of these other issues, because there was a lot covered, and not all of them have been decided on, but a lot of them were argued recently. The text messages and the 911 calls. So there was text messages between the surviving roommates. We've all kind of seen a lot of that. And they made a 911 call, which has now recently been released about 8 hours or so, I think, after the murders are believed to have taken place. And the defense is arguing that much of this is hearsay. And the prosecution's argument is that while it is out of court statements, it falls under these excited utterance exceptions. Where did things end up on that?
Yeah, I mean, you're the attorney here, so you'll probably have to explain some of those things a little more specifically. But for those who have, again, following the case, a 911 call was placed just before noon, and police believe this crime happened between, I think it's 2:15, around that timeline, in the morning that same day, earlier that morning. And the phone was passed around between 4 people. 2 of the surviving roommates, we're seeing one on the left and one in the middle next to Kaylee, and between Madison Mogan there in this photo. And then 2 friends who came over, a boyfriend and girlfriend, who also knew Xana Kernodle, who's on the right in this frame, and her boyfriend, Ethan Chapin. And that gentleman came over with his girlfriend from a nearby apartments, and they also ended up on the phone expressing some of the information from 2 of the roommates, including that they saw a man in the house last night. You spoke about, Joshua, about no eyewitness, but I think maybe we could even discuss that a little bit too, to what extent one of the surviving roommates arguably is an eyewitness, just can't identify Kohberger directly, and has been open and acknowledged that
literally my next note.
Yeah. Well, so here I've transitioned us, but before we segue to get to your point, so a 911 call, for anyone who's heard it, it's awful. I don't mind sharing an opinion about that. It's difficult to listen to, especially because we know what happened. I'm not sure, and I think we learned in the course of that call, the 2 surviving roommates and the friends who came over, they were not aware of what had happened. In fact, that's how the call starts. Something happened in our home last night, and they're trying to figure it out live with the 911 dispatcher. It's a hard listen, but the question is, will jurors get to hear this call and in its entirety at trial? The prosecution is pushing for that. Hippler pointed out and had significant questions for the state about hearsay issues. They made arguments about the excited utterance, what qualifies, and can you hear something secondarily and then offer that information and it be taken whole cloth? So he withheld a written, or actually a bench order on that particular issue. The defense said there's actually a lot more to these text messages than has been revealed by the state thus far, including the roommates browsing their phones on Instagram, Snapchat. One of them apparently was actually editing a resume as some other element, editing photos. And so they want to basically provide the comprehensive back and forth and phone call log between the 2 surviving roommates to provide context surrounding the 911 call. Hippler did say that there were some hearsay potential issues, and he's looking to thread the needle on this in order to grant what the state wants, and that's to provide the entirety of the call. But it does sound like he was thinking of some guardrails and saying that, we may need to redact some of this call. He did say the majority of it would likely make it in, but again, he has not ruled yet, and will need to rely upon Idaho criminal rules to make that, and court precedent to make that decision.
Interesting. Yeah. So not to get too into the weeds, but basically what the defense is saying is that they don't want these are out of court statements. That's true. They don't want them being, but hearsay is only out of court statements offered for their truth. So in other words, if you're trying to prove the truth of what is being said in a statement. So a statement like, I just saw a guy, he was wearing a mask, I'm so scared, that would be offered for the truth that they saw a person at that time. Now, what can add some reliability to that statement is if that is, a present sense impression that the person is making. They're describing something as it's taking place, or an excited utterance, meaning you're saying something while you're still under the stress of having just witnessed that thing. So there are plenty of exceptions that I think might apply to some of the text messages. The 911 call, again, a lot of what they're saying is not being offered for its truth. They're saying things like, I don't know if she's breathing. Well, it's not really the prosecution's contention whether or not they were breathing at that time or not. This is all just to kind of add, maybe just even color to what was taking place and when they discovered things and when they made 911 calls and everything else. So I really don't see much of a reason for the judge keeping it out. But again, I applaud the judge for being thoughtful about these things. Just kind of as an interesting aside for the defense, if it's not your client who was there, then what do you care what people are talking about and what they're making 911 calls about? But okay, fair enough that you want to argue each and every piece of evidence that comes into this case. But I would be shocked if a lot of that was kept out. And I do think it's interesting that the defense does want everything else that they were up to brought in. And I think the only argument behind that being that they were not all that concerned by what just took place, because they went back to being on Snapchat and working on their resume after they had just seen this thing again. How that helps them when you're claiming that wasn't your client in the house anyways is a connecting of dots I'm not really making right now. But, again, you got to make these arguments when you're heading into a trial of this significance. So, but to your point, there's a contention about eyewitness testimony. And there is what I would call a eyewitness in this case. And that's one of the surviving roommates, describes seeing an individual, gives a general description, height, build, that I would say is not inconsistent with the defendant. But the most significant thing being that at one point she describes him as having bushy eyebrows. And the defense is saying that even the use of that term somehow will lead to the inappropriate conclusion made by the jurors that she is making an identification of their client. Am I getting that right?
Yeah, it's kind of hard to wrap your mind around it. They're saying it's not him, and that they also said in a court record that Bryan Kohberger doesn't even have bushy eyebrows. And yet, if someone goes on the stand, if they're permitted to present that information and what they recall seeing of the individual, the man who was in the home, that it will have the effect on jurors that she is positively IDing him, even though, according to court records, she was not able to identify him directly positively after Bryan Kohberger's arrest and say that's absolutely him. But again, what we do know is that Bryan Kohberger does fit a general description of the things she said. She's a fairly tall young woman, and she said she told police in interviews repeatedly, over 5 interviews, that the man in her home was, not overly built, but athletic, and maybe just a few or a couple inches taller than her. And she is, I believe, 5'10" or so. And so taller than her, and in all black, and wearing what we're now understanding was a balaclava. It's not a term she knew or said, but she drew it for police. And that does appear to be what it is a balaclava mask that goes over the majority of your face, except for your eyes and your brow line. And that's the thing that she recalled seeing. I don't believe she said it in her first interview, but once she was asked, and the defense is saying prompted, but that is more of a question, and what the judge has to determine. And this is one of those handful that Judge Hippler did not rule on. This, I think, is a pretty significant issue to determine. And the state is saying, hey, let's let the jurors decide if he has bushy eyebrows. She said it consistently in interviews. And we've now seen what has become kind of an infamous photo of Kohberger that the state says he took the next morning. Here it is. And said, and the reason why we know about this is that the state put it into a court filing in response, one of those 170 court filings over the motions in limine, and said, great, they dispute that he has bushy eyebrows. Let's let the jurors see this image, something we intend to show them, and let them make a decision whether or not those are bushy.
Yeah. Yeah. Yeah, this has become such an interesting issue to me because of what you just pointed out. I don't know if this photo would have become as pivotal if it weren't for the issue about his eyebrows being brought up by the defense. And as you were talking, I was thinking it's funny because the description of bushy eyebrows is to somewhat a subjective standard, right? Like there is no, it's not like a yes or no, someone has bushy eyebrows. I guess it's up to interpretation. To me, it would be almost, and I'm trying to think of an example, and this might not be the best, but if the witness described the suspect as being tall, tall means different things to different people. To a short person, you know, the majority of the population might be tall. To a taller person, they might not describe all that many people as tall. So it, you know, for the person to give a general description of height, general build, and one thing that I can tell you is I thought he had bushy eyebrows. I don't see how that is so patently descriptive that even the jurors themselves can't make their own determination. They could take a look at him and say, well, I don't think they're bushy, or they could take a look at him and say, I absolutely do see they're bushy. But that's the whole point of a description, right? Is that, you know, then you attack whether or not that person could be relied upon to give an accurate description. But just because their description happens to include a general subjective observation, the then jumping to the argument of they should not be allowed to make it because the jurors might inappropriately think that that's an idea of my client, just seems like a bridge too far in my view. But am I getting right what they're basically trying to argue?
Yeah, no, you are. And I don't know. I mean, you're again the attorney in this. In between us, you're the one with the law degree and have practiced law. And I do wonder what the effect would be, the psychology of somebody saying definitively, I saw this aspect of the individual in our home around the time that we believe this happened, and this is the individual who happens to be in the courtroom, and people are going to be looking over and wondering. And if this photo is admitted as evidence, the state is saying, we don't care what he looks like in court. We're showing you what he looked like roughly 8 or what was it? It was about 6 hours. They say this photo with Bryan Kohberger snapped this selfie in his bathroom in Pullman about 6 hours after the crime.
I fully don't believe we're going to have a moment in court where they're going to ask this witness, do you see that person, a person matching that description sitting here in court, and that they're going to point over to Bryan Kohberger. I don't believe that'll take place. But what will be interesting is, will the prosecution have the guts to put up this photo and say, do you see the eyebrows of the person depicted in this photo? Is that consistent with what you saw that evening? And whether or not they're willing to go as far as to ask them that, or for the defense saying, I just can't imagine anyone pointing at Kohberger and saying, is it consistent with his eyebrows? Because then that would be about as close to an idea that you possibly could get. And it's going to be interesting to me who wants to play chicken with this witness as far as they can take that bushy eyebrow description and actually linking that to Kohberger.
That seems risky. And I guess
yeah.
You know, I'm not a legal analyst, but this is maybe akin to when Prosecutor Darden forced the issue of
gloves,
OJ wearing the gloves. And I think we all knew, and I'm dating myself a little, I was young at the time, to be clear, but I mean, it was one of those momentous things, and perhaps the case was won or lost on that.
Well, we're still talking about it to this day. It was such a colossal misstep by the prosecution. So I don't know. You know, but I feel like had they asked her that question already, that likely is something that they would have had to turn over to the defense. You know, whether or not she gave a yes or no answer to that, and they may just be playing it safe and saying we don't want to get close, because the disaster for the prosecution would be her to take a look at that photograph and go, no, that's not what I meant by bushy eyebrows. Then you've got major problems with her ID quote unquote, her eyewitness ID of this suspect, and that being Bryan Kohberger. All right, let's move on to the alibi defense. Now, the defense is saying, the prosecution is saying, listen, if you want to bring an alibi, Idaho has a rule that you have to present evidence of that so that we can properly investigate it and perhaps impeach it, and that you provided nothing other than to say generally he was out driving around, perhaps looking at the stars, perhaps doing something else, but he wasn't committing the murders. Now they're saying through this new expert, and we've heard a lot about this gentleman, Cy Ray, he's going to say through data, cell phone data, and specifically kind of triangulation of cell phones, that they can partially corroborate that, which is a interesting way of classifying it. But they're saying that we can put him in locations that aren't the scene of the crime at different points during that evening. And the prosecution says, yeah, but you can't place him somewhere else at the time of the crime. And the only person, therefore, that you're left with to testify to that would be Bryan Kohberger himself. Where does that argument leave us now with the judge?
On Wednesday, Bill Thompson, the lead prosecutor and the elected prosecutor in Latah County, laid out exactly what you did there, which was, hey, we demand that he testify to this. If this is what yep, there he is. If you're going to try to present this according to Idaho rules, one way you could do that is you could have him testify. I think we can agree that we were talking about risk. That would be a significant one for the defense because of cross-examination opportunities. They have not been able to provide any corroborating witness on this alibi issue. And so the state has said he either has to testify or you have to drop this as a potential defense. And Hippler did rule on this. I wouldn't call it a bench order, but he basically said, look, if they're going to provide another witness who can corroborate, let's call it full corroboration, I guess, since we're talking about partials, anybody who could corroborate this alibi has not been presented. And you know as well as I do, Bill Thompson, if the defense is going to offer somebody who is able to do that, they will have to disclose that ahead of time, both to the court and to the state. They haven't done that yet. And so basically his ruling was status quo. This partial corroboration issue was something that Thompson said, this does not fit the standard in Idaho. And it's troubling and concerning that this would be allowed to be permitted. Hippler reminded him that, okay, so Kohberger's phone was allegedly off during this particular window. And we agree. They don't have anybody who can say where he was in that window. And the cell phone expert, Cy Ray, can't either, because he doesn't know where he was. He might know where he was before and he might know where he was after, but nobody else beyond Kohberger can say where he was, at least as far as we know, and the claim associated with the alibi.
Can we go back to that picture of Thompson? By the way, I just got to point out that this guy is, I feel like, right out of central casting of what you don't know, some sort of what I would expect a Idaho grizzled prosecutor to look like, just kind of a coming in with a glorious look on his behalf. But this the one kind of confuses me, because alibi traditionally means I wasn't there, I was here, and here's the proof of that. Here's a person who's going to say I was there. Here's a receipt from here's a movie ticket, a ticket to a movie that I went to. Here's a receipt from a credit card purchase that I made at a different location. But this idea of I wasn't there because I was somewhere else that I cannot provide proof of, that's not an alibi to me. That's just calling into question the prosecution's evidence as to where you can put me, right? I mean, there's a difference between attacking the prosecution's evidence as far as locating the defendant and actually providing an alibi. And again, calling it partial corroboration, like you said, okay, you're going to show that he was here and you're going to show that he was there, but you can't show me where he was at the time of the murder. Again, does not seem to be alibi to me. So I guess I kind of agree with the judge in the sense that it's like, all right, well, then this is a bunch of stuff to argue. Present your evidence, make your cross-examinations, and then make your arguments at the end. But no one here, I don't see anything yet that it rises to the level of alibi that I feel like needs disclosing. Is that kind of where he falls on this?
Yeah, and Thompson was accepting of Judge Hippler's direction, and that, look, you'll have a heads up as much as the court has a heads up if the defense develops another witness. And I will note that Ann Taylor, the lead attorney for Bryan Kohberger, said they continue as a defense to investigate and explore, that's her, and attempt to find that witness who can corroborate the narrative they have put out there about Bryan Kohberger's whereabouts, not in Moscow around the time of the murders and the time that the state believes they happened.
Incredible. I just got a couple of more. Do we have you for a couple more minutes? I just got a couple of more things here. I want to be respectful of your time because you've been so generous with us. This one was interesting to me. Apparently, the prosecution, we don't have a picture of this. Despite Kaylin's best efforts, she can't find something that has never been disclosed to the public. So I forgive her for that one. They've created a 3D model of the home. The home has been destroyed, which a lot of people, including myself, had problems with that. But apparently they modeled this so specifically that they've now 3D printed, is my understanding, a obviously not to scale, but a model of the home that they intend to use for they're calling it illustrative purposes during trial. How did that all play out in court?
Yeah, I mean, this actually.
Have you seen it, by the way? Have you seen the model, a picture? Okay.
No, I was in the courtroom, and Bill Thompson did actually show a piece of paper that he labeled the exhibit, but he showed it toward the camera and toward Judge Hippler, and the live stream didn't pick it up very well. And I was in the back seeing the back of everybody's head, so I couldn't see it either. Okay. But what he did describe was the size of the thing, and it is pretty big. It's going to be 4 feet tall. So this is something that's. Yeah, so this is something that's going to live in the courtroom. The intent is for witnesses on the stand to point to, whether it's one of the surviving roommates talking about the sight lines at which from where they were standing and what they could see maybe at the sliding glass door on the second floor. It could be where certain evidence was discovered. It'll probably be the layout of where the bodies were and where they were found by police. It's going to be things like that. The defense was very upset, argued that this was information given to them kind of last minute. They've argued that their expert on this particular issue doesn't have the time to review it. As you noted, it's not to scale. And if it were to scale, it probably creates greater issues for the state, because then they would try to have to get it admitted as an exhibit. That's not what this is. And Idaho's rules are that because it's for demonstration purposes only, and it relies upon 3D imaging that the FBI conducted and actually is being constructed by the FBI, that the rules are slightly different. It's only for, again, illustrative or demonstrative purposes only, and it is not a piece of evidence that would go back with the jurors during deliberation. So it's just for them to see, for people to point out. It can be kind of deconstructed according to Thompson, and we could pull apart the different levels, and it's just so there's sort of a map in front of people who have to make the decision. And although the defense was very angry about this, alleged it violated Bryan Kohberger's constitutional rights, was an appealable issue, Judge Hippler noted that that is not the standard for a demonstration-only piece of information, not an exhibit, not a piece of evidence, and he allowed it.
That is very interesting. So did they say that they specifically made it not to scale because they intend to use it for? Interesting.
So the difference was, if it was made to scale, I believe the defense would have a greater opportunity to review the thing and point out from their own visits and walkthroughs of the home that hey, this is right, this is right, yeah. Right, and that's what they said too. This could misconstrue information. It doesn't give us an opportunity to say whether or not it's right or wrong. We've never seen the thing outside of maybe a photo that was exchanged between the two sides. I actually asked for that public record between an email exchange and was denied. So I made best efforts to give the public a view of this thing, but it's not been granted yet. But like I said, this is going to be a very large model, 4 feet tall. I believe it was 4 feet wide and maybe 3. I'm trying to remember. It was, I think the length was 3 feet. So it's going to be a significant exhibit. I'm calling it an exhibit, but I mean, Thompson kept referring to it as a dollhouse, basically.
Probably not the right term to be using for something in a case like this, but that is interesting. I mean, it's not, they're not reinventing the wheel here. I mean, listen, I've seen many times where, posters will be used in court. That are kind of a diagram of the murder scene and where people were standing. And they say, this is not to scale. This is not a accurate depiction of the measurements, but this gives you a general understanding of where each person was positioned. And that's used routinely. I just hadn't thought about it being done in 3D format and as large of a 3D format as you're talking about here. So the judge did, but end of the day, the judge allowed it and said, listen, I'm sure it's going to be explained to the jury again and again and again. It's not to scale and only for purposes of understanding where people were positioned. But that's interesting. He did allow it.
He did. And despite a pretty vocal and extensive argument from Ann Taylor, and again, she raised constitutional rights issues, non-disclosure of information from the state in a timely manner, which ports over to some of the other arguments that have been made to this point, and also over the death penalty in the latest filings. I mean, we could talk about that if you'd like.
That was my next point. Did I give you my script ahead of time or something? How do you?
It's almost like I know the case.
I know, right?
So I mean, Ann Taylor was very upset, and I mean, you could feel the sting in the courtroom.
Was there an indication as to when the defense had learned of this? Because it's almost sounding like they were caught off guard by some of this.
Yeah, I think in earlier days, and Thompson said this in court, there was an intention of actually developing a 2-scale model based on the 3D imaging the FBI did. I want to note, by the way, part of Hippler's point when he ruled from the bench on this issue, he asked directly. He said, Ms. Taylor, did the defense have plenty of time and opportunities to go through the home? And she said, yes. And he said, well, then you could have made these models and images yourself. And if you blew that opportunity, that's on you. You had as much access as you needed. And to the extent that you stipulated to allow this home to be knocked down with the state, everybody agreed at the time, hey, we've had our run through there. We have everything we need. Nobody was upset at the time, at least from attorney's standpoint, about this thing getting knocked down by the university. So again, Judge Hippler did allow this. He does want to see it sooner than later. The FBI was still constructing it, according to Thompson, and it's set to be revealed in the coming days and weeks, I think, between the two parties. And to your question, yes, the defense said that they did not have a great enough heads up about this, and they will have an expert who reviews it based on the dimensions and the specs, and they want that sooner than later. And the judge said, hey, prosecution, you do need to get that turned over to them sooner than later.
Wow, that'll be interesting too, because I imagine they're going to sit that right in front of the jury through much of that trial, just to continue to be able to refer back to it easily, and that will be kind of a constant, just subliminal reminder to them of this horrible event if they're not already thinking about it. All right, you had mentioned this. The defense has been laying the basis for some time about getting discovery late, including this argument about the model of the home, because they are trying to, and so far been unsuccessful in making the argument that these late discovery violations should therefore make him ineligible for the death penalty. And they reference the Lori Vallow case. Could you kind of walk us through that?
Yeah. This has nothing to do with the current case. In fact, I don't even know where that stands. Lori Vallow defending herself in Arizona, but this is from her prior murder trial. And in that situation, there are some differences in how those played out. Lori Vallow Daybell never waived her speedy trial right, which is a really critical element here, whereas Bryan Kohberger did, to present a greater chance for his defense to build the case in his defense. And so as a result, he did not have to go to trial within a 6-month window, which is Idaho's requirement. So, it laid the groundwork for the defense to do more work and build their case. But what they're now saying is, and they've tried to make this point several times, that throughout the discovery process, which I think, as your followers know, is when evidence has to be passed between the two sides that's intended to be used, or what interviews look like, all the details, all the emails, all the investigatory documents, they have to be passed and exchanged. But they're saying that most recently that the state did not meet the deadlines for turning over expert witness information, not only who they were, but what their backgrounds were and what they would intend to testify to. And Ann Taylor said repeatedly that this is actually kind of the last straw. This has, up until this point, they've been able to deal with this, and they didn't intend to go to the mat on this issue. But they said this now has delayed us significantly in building our own defense for Bryan Kohberger. And it's almost insurmountable at this point as we approach what is a trial date that is believed to be set in stone. And she used that terminology in court. And Hippler's response was basically like, why am I only hearing about this now? You could have filed something over this. And she said, yes, but Judge, the issue is now exacerbated by the fact that the expert witnesses have continued to be delayed. It has delayed us and what our responses are. And the state has taken advantage of the fact that we had to meet our deadline. We gave everything to them, and then they basically could build responses and what the testimony might be from their experts. So she was very upset. Judge Hippler, I wouldn't say took terribly kindly to this, and pointed out, well, hey, if you needed more resources, you should have been asking for additional paralegals. He said, you could have 5 or 10 more paralegals if that would get you there. She acknowledged that they got a third attorney on a swap out with forensic background. And my opinion on this is that I don't think Hippler is ultimately going to go for this Vallow-Daybell argument. A precedent that was set in that case had never happened in Idaho before, where the judge struck the death penalty over repeat violations by the state, including in just a couple weeks ahead of when her trial had to start. He said he had no other recourse. Typically, there are other penalties you can invoke on the state. You have to lose certain pieces of evidence. A certain expert can't testify, those types of things. But he basically said, my back is against the wall on appeals issues over this, and we're going to lose the death penalty as a result. The Kohberger attorneys are now trying to lean into that. In fact, Ann Taylor, in a different case she's representing, also death penalty eligible, is trying to make the same argument. So this is clearly a strategy on her behalf for her clients. But she's saying that, yeah, this is too much. You have to strike the death penalty. It's the only way to remedy this issue at this point. Hippler did not rule on this issue, to be clear. It's forthcoming. He provided, I would say, some guidance to the defense, said, hey, I actually extended the opportunity for the state to provide over disclosure on the defense and to amend those things. But I would be shocked if he were to lean into that Idaho precedent based on the Vallow-Daybell case and strike the death penalty for Kohberger in this situation.
Yeah, it's not a surprise that she's bringing up the arguments with this kind of recent precedent set with the Vallow case, which basically, in the legal world might as well have happened yesterday, as quickly as the case ended to when this case is beginning. And as you're talking, I'm thinking, don't be surprised if this isn't the last time she brings it up. I'm sure there will be some issue even during trial where they feel like they're getting something late, and they'll bring this up again and press on him to remove the death penalty from the table. Because I do firmly feel, and we've talked about this before, that they feel like mission number one in this whole case for them is to get that death penalty off the table in their defense of him. You got time for a couple of questions, or?
Sure. Yeah, let's do that.
You're going to kill me, but you're the best. All right. Let's look at some of these because people have been very patiently waiting. We've got some great questions. Jenna Bell says, how long was it between the killing and his car being searched? Do you know that?
I do, because the homicides happened on November 13th, 2022. They arrested Bryan Kohberger in eastern Pennsylvania on December 30th of 2022. And the car was almost immediately searched.
Oh, so no, we're not talking. Oh, sorry. Say that again. How many days from the murders? I missed that part.
7 weeks. So November. Okay. Yeah. So November 13th to December 30th. I will note that Ann Taylor said in a court hearing that they stripped that car down. Apparently, they took apart the key fob. They took apart the brake pedal, and I believe the stick shift. All of that. And they, her point was they didn't find anything. but there were repeat occasions where they did search the vehicle. But I guess I'm being general here, but certainly the car was searched, shortly after he was arrested, and it sounds like several times afterward as they continued to dig through the thing.
Yeah. But I think to Jennabel's point, and I hope that's where we were going with it, is that that's enough time for somebody to try to clean a vehicle. Now, if you're stripping it down to find whatever you possibly can, that still kind of raises the question of why didn't you find anything? But I've made this point, time and time again, that the absence of evidence does not mean evidence of absence. So they just could have not found it. Doesn't mean that it simply never existed, but it is. If I'm the defense, this is one of the points I'm hammering home as much as possible, is that, the only thing linking him is that DNA. CH says, to that point, how does the state bring in the tip without mentioning the IGG when the lead investigator has already testified on the record that he got his name from IGG? So this goes back to the prosecution is not planning on presenting to the jury the entire kind of tortured history of how they arrived at Bryan Kohberger, but they're simply going to explain that in short form as a tip. Has that been talked about and argued between the parties?
Yeah, so there was actually both sides filed in this situation. The state has long maintained they never intended to provide any information about the FBI's use of IGG. It was absent, as we all know, from the probable cause affidavit, which alarmed the defense and became, a months-long battle over the records, et cetera, et cetera. We get to the point where, I hate to say it, but at least in this case, it's not going to play a role whatsoever. And that's because this has already been ruled upon within the pretrial motions back and forth and a decision that was made on that issue. But both sides had to decide, well, how are we going to address this issue? They both filed motions in limine about this, and this was discussed on Wednesday. Hippler basically advised, hey, the state has agreed not to use it. The defense is acknowledging that will be the situation. It will not be addressed before the jury. And that gets to the question that your viewer has brought up here. How do you get around that? And Hippler advised you need to come up with some sort of solution. You two need to work together to come up with how that's going to be described. And at least from the initial information we received at that hearing, the lead detective in the case, a Moscow police officer, will basically say that the FBI provided a tip or a random tip came in, basically. And so they started investigating Kohberger as a result, starting on December 19th.
Interesting. The JC Broadway says she gave, talking about the eyewitness and whether or not, because there has been question about this, I've seen, and I at least in the Twitter sphere, about whether or not the investigators were perhaps suggestive of some descriptions to this eyewitness. Do we know if she gave that description about the bushy eyebrows before Bryan Kohberger was even on their radar?
That's a different question than I think what your viewer has there. I apologize. I'd have to look back at when the interviews were. She was interviewed immediatally, and this was not part of the description. But I'd have to look back at what those dates were. That's okay. But she gave an initial interview and never talked about eyebrows, right? And then it was later that. Right. Okay. Go ahead. Sorry. It's okay. That's part of the defense's argument. This was not something she brought up in that initial interview, and perhaps not even in the second of 5 interviews. I did use the term prompted. Perhaps that wasn't the right way to describe this, but was she suggested toward that? And it was my understanding from court was they said, well, did you get a look at the eyes? And then that's when she started to maybe remember, but she's stayed consistent since, at least according to the state. And that gets into whether or not it will be allowed or not, because she testified to that specific issue. The state, the deputy for Bill Thompson, Ashley Jennings, said in court that is simply not true.
Interesting stuff. Sir, you are so tremendous for sharing with us your wealth of knowledge on this case. Thank you again for your time. Thank you again for all the help that you've given to this channel on this case. Before I let you go, is there? I know everybody knows you're doing this work for the Idaho Statesman. Is there social media or other places that people can follow you and kind of get updates on these things?
Yeah, I mean, this is actually a decent opportunity to put a plug in for this on
Please.
Facebook with Mike Baker of the New York Times, who has also followed this case probably too closely, along with myself. But we have a Facebook page that people can go to. We kind of explore some of the most recent filings and rulings, and also I post a lot of the Idaho Statesman stories, including those from my colleague on this issue, Alex Brizzi. You can of course go to idahostatesman.com to read any of our current and past work and future work. That's the best place to go. I'm also on Twitter. It's at @KFixler. It's my first initial there, and then just my last name. And I post all the updates from myself, my colleagues, and those are great places to go if people want to continue to stay close.
Fantastic. Thank you again, my friend. You're wonderful. I know you traveled today. I know you carved out some time for us, and I really, really appreciate it.
Hey, thanks for having me on. Okay.
Have a great night.
All right, you too.
Oh, cut him off right at the end, of course. He's fantastic. I'm so grateful for it. He's like an encyclopedia when it comes to this case, just knowing. I feel like I'm always going to find some question that might stump him, and he has the answer at the tip of his at his fingertips. So thank you again to Kevin for all of that. We're going to get to our poll. While we are calibrating the numbers on that, I want to thank Stacy Nee McFarland for becoming a member, and Andrew C for being a member for a month. What else do we got here? Member for 7 months, from Farm Girl, saying she's so grateful that she's a member of this community. I'm so grateful that you are too. Thank you. Donna Barnes, thank you so much for the super sticker. Alicia Reed became a member. Appreciate you. Thank you guys all so much for sticking around, and stick around because we're going to get to one of our polls at least. And then I do have an announcement that we're pretty excited about at the very, very end. So please don't go anywhere till we get you those announcements at the end of all of this. But what was the results, Kaylin, of our poll? She's given me the hold on 1 second calibrating look. 40% Henry Tenon. I'm surprised by that. Is that the winner, Henry Tenon? Interesting. You guys kind of shocked me. I did not think that we would be doing talking about that case. It's very interesting developments in this case. So this is the case of the murder of Jared Bridegan. He was a Microsoft executive. We did, by the way, just to give a plug to Courtroom Confidential, we did a case notes episode on this case as well. This case is fascinating. This case is getting a little bit of attention, but not as much as I feel like it really deserves, because it's one of those cases that is just so intriguing. It involves Mr. Bridegan, who we're looking at here, his ex-wife, Shanna Gardner, and her new husband, Mario Fernandez. That's the both of them there. She comes from a wealthy family, I believe from Utah, marries Jared Bridegan, goes through an ugly divorce, and then, according to the prosecution in 2022, Shanna and Mario hire Henry Tenon to commit an ambush-style murder of Jared Bridegan. And the way that they did this is just kind of diabolical. He was picking up one of their shared children, who was, I believe, 3 or 4 at the time, had the daughter still in the car seat in the vehicle, knew where he was going to be because he was going to go from mom's house to dad's house, and knew what path what road that would take him down, and put an obstacle in the road, a tire in the road, so that he would have to stop, meaning that he would have to stop and get out of his car to remove the vehicle. And at that point, he was ambushed in a absolute textbook lying in wait type murder shot to death in front of his daughter, the toddler, who gave a statement to police, something about daddy sick or daddy fell down. It breaks my heart. Again, we have all of the details, as far more accurate than what is coming to my memory right now about this in our case notes episode that you guys should check out. But this case broke when the prosecution was investigators were able to track down Henry Tenon as being their prime suspect. And then through Henry Tenon and some bank transfers made to him, payments made to him, relationships that Henry Tenon had, track it back to Mario Fernandez and Shanna Gardner. So the linchpin of the case for the prosecution against Shanna Gardner and Mario Fernandez, who are facing the death penalty, by the way, is this person here, Henry Tenon, who has agreed to cooperate with the prosecution and say everything, which is interesting here because now the prosecution deal is being extended to the actual trigger man, the actual person who pulled the trigger and responsible for the murder. The prosecution feels is somehow less criminally culpable, and I agree with this, than the people who orchestrated and planned it and hired him to do it. And I've been involved in cases like this before, where it really is not even the person that you're claiming was at the crime scene. There's no allegations that Shanna Gardner or Mario Fernandez were anywhere near the crime scene when this murder took place. But they are, for the purposes of criminal culpability, far more responsible than even the person who pulled the trigger, Mr. Henry Tenon. But realizing then how important he is to the case, you'll understand why now these recent developments were troubling. Back in January, during a hearing, he told the judge, London Kite, that there's the judge, that he wanted something to say. And when this ever happens in court, everybody, you hear the sound of the defense attorney scrambling to talk to their client, and you hear everybody saying, okay, wait a minute, let's hold on. The prosecution perks up and wants to hear what's going to come out of his mouth. And the judge says, talk to your attorney, don't talk to me, speak to your counsel, And he, despite all of that, blurts out, I just want to bring to your attention that my testimony, and then she's telling him, no. And then his next words were false testimony before she cuts him off and they bring him back to lockup. This is incredible. This moment must have just dropped jaws in the courtroom. Unfortunately, none of this was there were not cameras rolling inside the courtroom, but you can sure the prosecution just was losing their minds here because now their star witness is making allegations that his testimony may have been false. His attorney then speaks with him, and he says that, or his attorney then makes the statement, this is Alan Chipperfield, to the judge, that he believes, this is a quote, I told the state that I suspect that there may be an inmate at the jail who was influencing Mr. Tenon and that a co-defendant had gotten to him. It was me trying to figure out why my client has surprised me in court. So he was caught off guard by this as well. And his suspicion at the time was maybe one of the defendants somehow through the jails gotten to him and made him, we're trying to put pressure on him to recant. So that all brings us to this Tuesday, just yesterday. He was back in court, and first he says that he has in no way been threatened, paid, or harassed since his time in jail. And then the judge makes these comments. When we last saw each other, you made a statement in court. I stopped you for you to have an opportunity to talk with your lawyer. Have you talked to your lawyer? Is there any need to go any further on his representation? Are you satisfied with him? So he also made kind of representations at the time of, I don't want this lawyer. I don't like this guy. I'm getting a bad deal. And Tenon responds, no, it's just that we had a misunderstanding before. We kind of overcame that. And according to the prosecutors who had an opportunity to speak with him, remember, he's a cooperating witness even though he's a defendant, he's cooperating. So they do have they have been speaking with him. They, according to their notes, said that Tenon was second guessing his decision to cooperate because he now believed his cooperation would not matter. And despite it, he would nonetheless be sentenced to life. Here's the problem with all of this. Brennan, by the way, Tenon, they have, I think, easily. The evidence linking Tenon to this is his DNA is found on that tire that was blocking the road. They have video surveillance showing him at the scene or someone matching his description. And they have cell phone data placing him at relevant locations. So this guy, they feel that they have. But this statement is interesting to me because he is what he's saying that's troubling him is not I was pressured by someone to change my testimony, not that I've been second guessing my testimony because I don't know, any number of reasons. But the reason he provides is that he feels like he would nonetheless be sentenced to life. So in other words, he is tying his testimony with any potential benefit he could get from it from the prosecution. That is a problem for the prosecution because you do not want your star witness to be motivated entirely by what they could be getting out of the prosecution by testifying. Because if you're the defense, you're going to have a field day with that. You're going to say, isn't it true you're willing to sing any tune that the prosecution wants you to sing if it will at all benefit you? Now, listen, most times people who cooperate are getting some sort of a benefit. That's true. And so most times they're going to be cross-examined on that. But most times they haven't actually laid it out themselves as to the reason that they're doing this or what their motivations behind it or why they're willing to even say they're giving false testimony at one time in court. So problems here, because in my view, without Tenon, and again, I'm going off of everything I've learned about this, and there's probably more evidence to this case than we know about, but everything that we have learned about this case and Tenon is if they don't have Tenon, he is the crucial witness in this case. If they don't have him cooperating, huge problem. But even if they do, it really depends on how the jury views him, which will likely be the result on whether or not they keep convictions against Shanna, Gardner, and Mario Fernandez. If the jury believes Tenon, if they find him to be reliable, trustworthy, they believe his veracity, they don't believe he's motivated purely by his own self-interest, then they will likely convict Gardner and Fernandez. But if they don't believe him, if they find him to be problematic, or they do question his veracity, then that gives a fighting chance to the defense to say, take Tenon out of the equation, and what are you left with? And whatever you're left with, whatever circumstantial evidence, whatever motivation-based evidence you have, we can provide you with some sort of answer to that. We can provide you with some sort of reason to explain why they might have been motivated to end his life. We can provide you with some sort of explanation as to communications taking place between our clients. What they can't provide an explanation for is why this man is testifying the way he is. So it really comes down to whether or not he's credible. If he's not credible, you can give the defense at least puncher's chance in this whole thing. So very, very interesting case that is playing out in Florida that we have been following and we will continue to follow. Thank you guys. Again, let me get to the announcements because we do have some really fun stuff coming up. First of all, what you missed on, do we have a question on that? I don't want to skip over if we had questions on that, Kaylin. If there's anything, go ahead and throw it up. I don't want to move on so quickly. Do we know who is on trial first? I believe they're both going on trial together. If I'm wrong about that, then I'm wrong, and shocker, but I believe they're both going on trial together. And I believe right now, as things stand, they are seeking the death penalty against them. So it's a crazy case. It's an absolutely fascinating case that, again, I don't think is getting as much attention as some other cases are, but I think it deserves it because it's It's important and it's high consequences. All right. What is your honest impression of Henry Tenon? My honest impression is he's telling the truth, but my honest impression also is that you could view that he's not entirely trustworthy, that maybe he's telling the truth, but maybe he's not telling all the truth, or maybe he's keeping some stuff out, or maybe I just listen, you don't get to pick your witnesses. This is what the prosecution is going to have to use going into this. They really don't have a choice, but I can guarantee you that these recent headaches have kept them up at night. Can the defense bring up that he claimed he was given false testimony? I think that they can absolutely cross-examine him for anything he said in court. I think that if he opens up the opportunity to say that his veracity is always at issue, and I'm sure that they're going to imply that he is giving false testimony. If he denies that, they could probably bring up the fact, didn't you in fact tell this court that? That's going to have to be litigated. If you're the prosecution, you see that one coming a mile away, and they're going to have to litigate that. All right, what you missed on Monday. We had in our Courtroom Confidential Conversation series an interview with Esther Ludlow. She is an OG true crime podcaster. She has the true crime podcast called Once Upon a Crime. She is so OG that her website is truecrimepodcast.com, which still amazes me that was available at the time she started her podcast. So really interesting conversation with her. Please check it out. That is already up. We did that. That was released on Monday. On Friday, we will have, on Friday, the Menendez case is back in court. If you guys are local or if you want to check it out, I will be on ABC 7. They've kind of told me, please just hang out at the station all day to talk about that case. So I'll be talking about the Menendez brothers on Friday. On Saturday, we have the release of our weekly roundup as per the usual. That will be at 6 a.m. Pacific, 9 a.m. Eastern for a live premiere. Please check it out. Lots going on this week. A lot for us to talk about. And on Saturday, we are going to be doing our monthly members-only live stream. So please, if you are in the classified and above level, please check it out. Always a great conversation. I try to bring some interesting story. We try to chat about, TV shows we're watching and everything else. And it's just a fun time, a lot more casual to talk about, answer questions and talk about whatever you guys want to talk about. That will be on this Saturday. Sunday, no Sunday fun day. It's Easter. Go chase down some bunnies. Go find some eggs. We will be doing that with our little ones. We hope you guys enjoy, but we will return with I imagine, big Sunday fun day the following Sunday, because we already got lots of questions and we love hearing from you guys. Monday, we are having the next interview in our conversation series with Mark Bowden from the Behavior Panel. This dude's awesome. This guy had me just wrapped up in what he was talking about. He is just a fascinating individual, fascinating speaker. We had an incredible conversation. He's from the very popular channel, YouTube channel, The Behavior Panel, and really enjoyed it. Please check that out. The premiere will be this Monday at 5 p.m. Pacific, 8 p.m. Eastern. Blue Bear Arts loves Mark. Terry L loves Mark. I love Mark. I'm a big Mark fan. And we had a really, really great conversation. You guys I really think you're going to enjoy it. We could have talked for hours, but we tried to keep it to less than that. Then on Tuesday, and here's kind of the big announcement. If you've heard already, we are working on a new project and we're launching it. It is called Courtroom Confidential Live Trials. It is a brand new channel. The what is it called? The handle to find it is called CC Live Trials. It's hard to locate. We're going to include the link for you guys so that you can find it and subscribe to it, because we don't have anything up. Because the reason we don't have anything up is that we are premiering our first live trial this coming Tuesday with opening statements on the Karen Reed trial. So the idea behind this is we know that you guys want to have a place to go and watch trials live, and that you want to watch them, be able to enjoy them, chat with people in your community, not have a bunch of commercial breaks. And we thought we don't want to put that on the Courtroom Confidential channel and kind of muck up the works. Let's just start another channel just for that purpose. So check it out. Please subscribe. We're going to be over there starting this Tuesday for opening statements on Karen Reed. I'm going to be jumping in, giving commentary where I feel appropriate, talking about, giving my reactions. But I'm not always going to be there either. It's also just going to be a place for you guys to know that you can go and watch these trials and chat with everybody in the Courtroom Confidential community. Again, we're going to add improvements as we can along the way, but this is the launch this coming Tuesday. So please check it out. Courtroom Confidential live trials, CC live trials. Search for it. We will include. I think we already have the link going up there. Please check it out. And then I'm giving you all of these announcements because I would give a lot of them to you on Sunday, but we're not going to have a Sunday fun day. So we're getting all the way to next Wednesday. We are going to have Scott from Recovery Addict on, and we're probably going to be talking about Karen Reed and a bunch of other stuff coming on. And I've been bugging Scott to give us a different picture of him because I'm like, you don't even look like that anymore, Scott. You got to give us your kind of updated photo. But he says, no, leave me alone. But I will be on Wednesday Night Live this next Wednesday to talk about that. Scott's one of my favorite people on earth, and he follows these trials closely, and he's going to be following the Karen Reed trial. So we'll be chatting. I'm sure we're going to be chatting about Karen Reed for the next few weeks, but covering other cases as well, because there's a lot of other things going on in the world, as you know, including the fact that we have some brand new members that need thanking. So to Isabel Park, Colleen K, Norma Guerra, 101 GM, Run the World, Karen Kruger, Viljone, Tehef, Vesper Martini, Stoshki Poshki, Tracy Reed, Helen O'Hara White, Sarah Volk, T-Mac, Blue Star, Joanne Goldman, Leslie, Blue Bear Arts, GG5, Misconduct, M, LA, or I don't know if that's LA or Law, Galen, Linda Francescan, and Stacy Nee McFarlane. You guys are all fantastic. You all made the decision to join the Courtroom Confidential crew as a member, and we are grateful to you for doing that. I think that's everything. I think we covered everything. Check out Courtroom Confidential live trials. Check out. Oh, do you like the shirt? Do you like this color? It doesn't show up so well because I don't know why I'm all washed out here, but this is, what color is this, guys? Is this olive green or something? I don't know what to describe this as, but with our little CC Crew logo, again, one of the new things we're offering. So we've got new merch, we've got new channels, we've got new members. We're trying, everybody. We're putting it all out there, and we're hoping that you're liking it. And we appreciate you all spending some time with us on a Wednesday night. Thank you all again. Deanie Mullis Diver, you can absolutely have one. Vester Martini says, I like the pastel colors. Yeah, we're keeping it real. It's springtime coming up. You guys are fantastic. Thank you again. We will be talking to you all soon. Take care, everybody.